I'm Christina Nasty. I'm a 2L here at Stanford and the director of the VLAP Pro Bono, the Veterans Legal Assistance Program. We team up with Swords to Plowshares to do veterans benefits clinics for veterans in the Peninsula area. So as John already mentioned, this panel will be talking about scope and eligibility for veterans treatment court, which is a topic that's come out throughout the weekend, but now we'll really dive deep into it. We have a great panel right here with us, and I'm going to turn things over to Professor David Engstrom to introduce everyone. He's a professor here at Stanford. He teaches admin law, civil procedure, and a host of other things. And relevant to this discussion, he's an Air Force brat. So with that, I will turn things over.
Great, thank you, Christina. So we're at the back end of the conference, but our final panel is on a critical front-end design question, scope and eligibility. I think of it as one of those devil in the details issues that my wife Nora spoke of yesterday during her presentation. And the basic question is a seemingly simple one, which is which veterans should be eligible for diversion into a VTC in the first place? And to work through this question, we really could not do better than the panelists we have assembled today. I'm going to introduce them all at once, maybe a little different from past panels, and I'm going to introduce them in the order in which they're then going to speak. So first up will be Brad Adams. He's the young buck of the group, but also wildly impressive. He's a veteran who deployed to Afghanistan as an officer in the U.S. Army Reserve. After separation from service, he spent 2 years working in refugee camps in Central Africa. He went from there to Harvard Law School, which we won't hold against him. I think someone used that expression on a previous panel. But then went on to a prestigious Skadden Fellowship at Swords to Plowshares. He stayed on there. He's now a staff attorney there, and he recently co-wrote what the National Lawyers Guild called a groundbreaking report on VA eligibility, and it's titled Underserved: How the VA Wrongfully Excludes Veterans with Bad Paper. And that report was featured, among other places, in the New York Times a couple of months back. I actually remember reading that. Next up will be Evan Simone. Evan is currently a professor at the Mississippi College School of Law in Jackson, Mississippi. And he is a leading scholar on providing legal services to veterans with PTSD and TBI. But Professor Simone is also one of those people who seems to have had 9 professional lives before entering academe. He's an experienced military trial lawyer, including 12 years as an active duty judge advocate. He did tours in Iraq and Germany. He served as a prosecutor in the Office of Chief Prosecutor of Military Commissions, where he was responsible for cases involving terrorism and acts of unlawful enemy combatants tried at Guantanamo Bay, Cuba under the Military Commissions Act of 2009. He was the Chief of Military Justice at Fort Bragg. Now, as a professor, he actively teaches and advocates around veterans issues. He still serves in the U.S. Army Reserve as a judge advocate, and yet somehow finds time to write award-winning scholarship as well. I note that he recently won the Meyer Elkin Essay Award from the Association of Family and Conciliation Courts for some work he did in the Family Court Review. So that's Evan. Last but certainly not least is Judge Stephen Manley of the Santa Clara Superior Court. I'm pretty sure Judge Manley requires no introduction for most of you, but just in case there are a few uninitiated out there, here's a thumbnail sketch. Judge Manley has served on the bench here in Santa Clara County for going on 40 years, first as a municipal court judge beginning in 1977, then as a Superior Court judge since 1998. But Judge Manley is no ordinary judge. For starters, he has a Stanford JD. Couldn't possibly be ordinary as a result. But more importantly, he's a founder of one of the nation's first drug treatment courts, the Santa Clara Mental Health Court, and most recently, the Santa Clara Veterans Treatment Court. I can't even begin to convey all the awards and plaudits Judge Manley has received over time, so let me just give you a smattering of some of them. As just one of many, many examples, in 2009, the National Alliance on Mental Illness awarded Judge Manley the Sam Cochran Criminal Justice Award, referring to his, and this is a direct quote, innovative thinking, and clear-eyed dedication to change. Quick Google search also turns up a selection of terms that have been used to describe Judge Manley. I'll give you a few of them. Innovator, visionary, tireless, passionate, pioneer, local institution, and huge heart. So thank you to all of you for being here. So in stark contrast to this stellar group, I'm your MC, little me. I come to this conference with very little substantive background in VTCs. As Christina noted, the best I can say is that I'm an Air Force brat and the son of a Vietnam vet. But I do have a background in legal procedure and also political economy. And so I wanted to start things out by saying a very brief couple of words, mostly at the level of 20,000 feet, about how we might think about eligibility questions when we think about designing these VTCs. One of the student panelists yesterday, Vina, one of my former civil procedure students, did a fabulous overview of the menu of ways that VTCs around the country have tried to structure this eligibility question. And I think it might be worth refreshing our recollection, even if only briefly, to help ground the discussion to come. Some VTCs, as Vina told us, key eligibility to service-based criteria. So for instance, whether a vet deployed to a combat zone or the character of the vet's discharge. So for instance, conditioning eligibility on having an other than dishonorable discharge. Other VTCs condition eligibility on particular clinical diagnoses or illnesses, so defined mental health problems or drug or alcohol addiction, or the criminal offense type. So some VTCs, in fact, I think all, have carve-outs for very serious crimes, such as murder or rape. And some limit eligibility to nonviolent felonies or misdemeanors. Still others combine these approaches, requiring that some verifiable mental illness or substance abuse problem be related to military service. I think Vina referred to this as a nexus requirement. And finally, many VTCs delegate eligibility questions to others. So for instance, some VTCs key eligibility to VA eligibility, or as we saw in the Model Uniform Act just now, they vest prosecutors with a say in who is diverted in cases, especially cases alleging use or threatened use of force in some states' VTCs or some counties' VTCs. So the interesting 20,000 feet question in all of this, in my view, is to ask what purposes these different slicings and dicings, right, of eligibility might serve. And I can think of four, and I'll just roll through them very quickly. First, and most obviously, we might care about eligibility because we have some vision of distributive justice or moral desert, right? So concretely, we want to reward veterans for service and sacrifice. It's one way to think about it. We might also structure eligibility, though, with a firm eye on economic efficiency, right? The policy wonks will tell you that you want to put resources to their highest and best use. And so perhaps we should key eligibility to something like a risk-need analysis of the sort that Doc Holliday just told us about this morning. But hopefully you already see some of the tensions that can arise then when we line up different design values, right? Different ways to think about eligibility. A moral desert frame militates in favor of a very expansive approach to eligibility, right? If you served or if you served in combat, you're entitled to a benefit, end of story. By contrast, an economic efficiency frame might militate in favor of narrowly limiting eligibility to particular kinds of clinical diagnoses. On top of this, there are two other purposes, though, that are hovering in the background and surface still more tensions. Right? When we think about eligibility, we have to think about the external legitimacy and therefore the political durability of the system. So many experts on social welfare state politics have noted a basic trade-off. On the one hand, if you set eligibility standards too loosely, right, you can create an undeserving recipient problem. It can actually erode the legitimacy of the program and impair its durability. On the other hand, the more universal a program is, it's also the case that sometimes that makes it more politically protected. So think of Social Security, right, as a social welfare program, right? It's protected politically precisely because it's so universal. By contrast, residual programs, programs that target very specific groups of people, might not be as politically protected and might prove more politically vulnerable. The final design value or the final purpose we might want to think about when we structure eligibility is administrability, right? Sifting cases, deciding at the front end who's eligible and who isn't, costs time and money. and it can deplete resources that could otherwise be used to provide the primary services that you're trying to get to people in need. So in other words, at some point, resources spent on determining eligibility in a program like this can sometime reach the point where they outstrip any benefit. So that's all I want to say. The panelists, I think you're going to find very quickly, have a far richer background in all of this and lots more to say. But I hope we can, at various points in the discussion, return to or at least keep in mind the basic reasons, again, at the level of 20,000 feet, we should care about eligibility, and also some of the trade-offs that the different approaches can pose. Okay, so with that, I will get out of the way and turn it over to the panelists, and that's going to be first Brad, then Evan, and then Judge Manley. So thank you.
Thanks so much. Thanks to everyone for coming and to organizers for organizing and inviting me along. So I'd like to talk about discharge characterization and conduct in service and how that relates to VA eligibility and VTC eligibility. Are there certain people who should be excluded from this because of how they behaved in service? I noticed yesterday there's a great group here, a mix of practitioners and academics, which is exciting. I wanted to speak to both groups. And so what I'd like to do is I'd like to talk about the historical origin of the VA's eligibility standard and how that relates to conduct and service. And then second, give practice pointers for people who are working in VTCs and are trying to steer people who are perhaps ineligible towards eligibility, because there are opportunities to do that. The historical piece is interesting for a few reasons. First of all, it gets into a little bit of statutory construction, so the academics can geek out on that a little bit. Second point is the statute, which was written in 1944, it's a bit dusty, is actually the last time that Congress has weighed in on this question. Congress has weighed in on the question of how bad should your behavior be to forfeit recognition as a veteran and access to basic services. So in a sense, that's the same question that VTC organizers and administrators are asking themselves: who should be excluded, who should be included, and why? So I'd like to share the thoughts that Congress had on that when they answered this question in 1944 and what answer they came up with. The third reason why I think the history is interesting is because it describes the standard that Congress wanted to exist. And so practitioners who are trying to steer people who are currently ineligible towards eligibility can have that in mind, that it might be possible, maybe with some obstacles in the way, maybe some hoops have to be jumped through, but it may be possible to get eligibility for this person because that's what Congress envisioned. He or she should be eligible according to the standard that Congress provided. I read a study, perhaps a lot of people here have also, that did a survey of VTCs, how they generally look at characterization of service and VA eligibility as entry criteria. About 1/3 require VA eligibility to participate. There's a practical aspect there because that's a source of treatment, and a veteran treatment court needs a source of treatment. So there's a practical element. But I imagine also tied into that there is a moral element or an ethical element, because the VA eligibility criteria incorporate a judgment about your conduct, one's conduct in service. And so in a way, by adopting VA eligibility as your criteria, you're incorporating their assessment of someone's in-service conduct. In addition to the 1/3 of VTCs who have VA eligibility as a criteria, also about half have some type of discharge characterization as a threshold criteria. And so even if they are perhaps VA eligible or VA non-eligible, they will be excluded from the VTC based on their discharge characterization. Those two numbers, the 1/2, 1/3, might overlap. Actually, the study didn't clarify that. So at least 1/2 of VTCs do have some exclusion based on conduct and service, maybe more. I'm going to start with a little bit of military cultural competency, because there's a lot that isn't clear to a lot of folks about this. First of all, military service is not separated into honorable and dishonorable. There's actually 5 characterizations, and then you can even be uncharacterized, but that's a separate thing. 5 characterizations: honorable at the top, dishonorable at the bottom, and a few in the middle. A lot of people misuse these terms. They use dishonorable for anything less than honorable, and that's not correct. You also notice there's one in the middle there called other than honorable. Some people use the term other than honorable to refer to anything less than honorable. That's not correct. some important distinctions to point out here, if you don't know this already, and I apologize for those who do. The bottom two are punitive discharges. It's a discharge as a result of a conviction at court-martial, dishonorable and bad conduct. The first three are administrative discharges. They are not the result of a discharge at court-martial. There may never have been any talk of a court-martial. There are some procedural protections in place. So some I's have to be dotted and T's crossed before a commander can give an other than honorable discharge characterization, but it's very, very loose. You can get an OTH discharge for very minor misconduct, certainly nothing that would land you in a court in the civilian world. You show up late to formation a few times, plus the commander doesn't like you, boom, you're out on an OTH, very easy to do. A single DUI in a unit that has a zero tolerance policy, boom, you're out on an OTH, very easy, it happens all the time. So it's important for us to know that this term OTH refers to a specific characterization, which is a non-punitive, although something happened, non-punitive discharge, although something happened in service. The range of conduct that might land you in that is very broad and can be very minor or potentially serious. The protections in there to assure that what was alleged actually happened are very, very loose, very minor. So if you're dealing with a service member as an OTH discharge, that's not a dishonorable discharge. They may not have done very much that's severe at all. They probably deserve your consideration and regard despite that. Despite that characterization. How does this relate to VA eligibility? There's some confusion about that also, so I want to clarify it. In practice, the VA treats as by default eligible the first two characterizations, honorable and general. The VA in their system characterize people with those discharges as honorable for VA purposes, HVAP, and those people will generally be considered VA eligible, with some exceptions like Reserve and National Guard, which I can talk about separately if people want to. But basically, as far as the conduct standard, first two characterizations, you're VA eligible, they call you honorable for VA purposes. If you have one of the three bottom characterizations, the VA treats you as presumptively dishonorable for VA purposes and VA ineligible. I want to be clear, in the practice point at the end, we'll get to this, that's a flexible standard. Someone can start out as VA ineligible and become VA eligible with that OTH or bad conduct discharge characterization. There's things that court personnel or social workers can do to make sure that happens. But before I get to those practice pointers, I want to get into some history. So the current standard was set in 1944, and in that law, Congress said, everyone who is discharged under conditions other than dishonorable should be recognized as a veteran and get access to basic veteran services. This was an important adjustment from the prior practice. Previously, Congress had established higher discharge standards. Civil War era, everyone was in, and then they excluded people with dishonorable, and then they excluded people with bad conduct discharges, and gradually the exclusion criteria was ratcheting up until the most recent, prior to 1944 statute, establishing eligibility, required a fully honorable discharge. World War II comes around, large-scale participation in the military, more awareness about what happens. So 1944, the GI Bill of Rights was proposed and discussed, and this issue was revisited. And what happened in the end is Congress decided, no, we're going to expand significantly the standard. So the only people excluded are those who were separated under dishonorable conditions. What are the factors that they considered when they made this decision? Well, here's several quotes from the congressional record on what they had to say about it. They referred to actual need. Yes, something bad may have happened, but they are, in fact, in need. They are, in fact, disabled, are, in fact, in need of employment support. We're not going to get hung up on what happened in the past, looking at their, in order to address their current need. They discussed public health factors. These may be problem servicemen. Well, they're a problem for society unless we solve that problem. We're not going to, spite our nose for our face by withholding support and care for them, even though they may have done something, improper previously. For all of our benefit, we're going to give them the appropriate care and service that they require. That was an explicit consideration at the time. Yesterday, the concept of a pressure valve came up. That was discussed at the time in reference to this really fascinating episode in history called, what was the name? The Benefits Army? The Bonus Army, 1932. The World War I veterans had been promised a cash benefit. Depression came around. government decided they didn't want to give it the cash benefit. Literally thousands of World War veterans occupied the mall, the National Mall, to demand that benefit. I recommend you Google it. No, wait, I'll Google it for you. Here's a picture. Here's just a fascinating piece of history. Here's a picture of them occupying the mall. MacArthur was ordered to disperse this encampment rather than give them what they wanted. He did so with tanks. So here are people with gas masks and World War I uniforms dispersing. And then they lit it on fire and burned the encampment down. So discussed in 1944 was whether or not this is what they want to see happen and whether or not they should just take care of the problem instead. An important one, a hugely important one, explicit recognition that mistakes get made and there are people who might end up unjustly given a prejudicial discharge characterization. And we should be expansive in our standard. We should be over-inclusive in who gets access to services so as not to make sure people who were unfairly separated are excluded. I love the first quote there. I know there's a couple other junior officers in there. I'm sure none of us were temperamental commanding officers who lacked proper patience and tolerance, but it certainly happens. It definitely happens all the time. And Congress said, look, we know it's going to happen. We can't stop it from happening. What we can do is make sure these people get caught on the back end by expanding our eligibility criteria. Similarly, at the end, we do not want the committee or Congress to cut off a hand in order to cure a sore thumb. There were people who disagreed, and those thoughts got expressed also. Some people said, hey, are we going to deny this hospital bed, deny an honorably discharged veteran this hospital bed in order to make room for this person who had a less than honorable discharge? And that got rebutted. Soldiers would rather some man got more than he deserved than any soldier would run a chance of getting less than he deserves. Not everyone felt that way, but some did, some didn't. That got explicitly put on the table. Finally, and this is important, there were some people who had the view, hey, look, the DOD made a decision here, the War Department at that time, the military made a decision to give prejudicial discharge. Who are we to second guess that? And that case was made very explicitly, very forcefully by the Chief of Naval Personnel. He said, look, we can't, we need to punish these people, and you're preventing us from punishing these people. That was explicitly put on the table. The Senate sponsor of it, who had been a colonel in World War I and went on to become a D.C. Circuit Court judge, rebutted that in the most, powerful ways. He said, no, these are the most stupid, short-sighted objections which could possibly be raised. That day, the bill passed with the current language, which is there right now, which is that you are a veteran if you were discharged under other than dishonorable conditions. So a very expansive, very low bar. So those are the factors that Congress looked at, and maybe we should consider also switching out to the implementation, the practice side. Well, so why is it, if that's what is the law, why is it that folks with discharges better than fully dishonorable are in fact being excluded? Well, there was a bit of a compromise that happened. The language is dishonorable conditions, not dishonorable discharge. What the VA has done in practice to implement that somewhat ambiguous statutory language is they said, well, what we're supposed to do is we're supposed to exclude people who did or should have received a dishonorable discharge, recognizing that some people who behave that badly sort of luck out and get a better characterization. We're supposed to exclude those people also, and that's true. That's what Congress said. So they said, all right, what we're going to do is we're going to take dishonorable plus bad conduct plus OTH, put them in limbo. None of you get anything until we do an individual review of your eligibility, like secondary screening at the airport. That's a regulatory decision. Congress never told them to do that. So when someone says, oh, OTH, you're a dishonorable, you're a non-veteran, Congress never said that. DOD didn't say that. That's a VA regulation. So first, they're put in limbo. Second, by regulation, it says, when you apply for a benefit, we will then do that individual review to see if you're in or you're out. What's essential here is it doesn't happen automatically. It doesn't happen the day you leave service. You have to apply correctly to get that individual review. For post-2001 veterans, only 10% have received that individual review. 90% are still in limbo because they haven't received an individual review. If a VJO does an eligibility inquiry of this person, it will say VA ineligible, even though no one has actually considered their conduct. They're just in limbo and have never left limbo. The third thing they did is Congress made standards by which that individual review should happen to decide if the service is dishonorable or not dishonorable according to the statutory standard. Do those regulations actually faithfully implement statutory intent? I say absolutely not, and I've studied it empirically and facially, and I can't wait to litigate it as soon as the VA blows off my rulemaking petition, but we can talk about that later. That's definitely getting in the weeds. So how does this look in terms of numbers? So here's a historical time series of discharge characterizations. The gray bar is dishonorable and bad conduct. Those are the punitive discharges, come from a court-martial. The blue bar is OTH discharges over time. Massive ballooning of the use of non-punitive administrative discharges with very poor procedural protections to separate people from service. This is a product of the professionalized military, which has shifted to a sort of zero-tolerance culture that simply didn't exist before. The standard of honorable service has increased. Because of the VA policy of treating people with OTH discharges as presumptively ineligible, it means that all of those people cannot access services the day they walk out of the VA. Maybe they will get that reviewed, but presumptively, no. Since 2001, 125,000 people have gotten one of these discharges that are presumptively ineligible. That's 6.5% of all service members. It's 1 in 10 Marines. It's a huge number of people that are placed in this limbo and never functionally leave it. Some service members will say, oh, dirtbags. No, 25% of those served in contingency operations, which doesn't mean combat, but it means some type of hardship conditions that deserve some regard. Putting this all together, so this is each broken down by wartime era. The total stack is the people that were placed in limbo because they have OTH, bad conduct, or dishonorable discharges. The top slice is the ones who have succeeded in getting an individual review and were found eligible. So they have an OTH discharge, but they are VA eligible. It's possible to happen. That's top slice. The second slice is people who requested that individual review and were denied. The bottom chunk is people who have never been reviewed. If you have someone in your VTC who is VA ineligible, they are almost certainly ineligible by default because no one has actually done a review of their service. Now, the standards are not particularly generous, but if you don't actually get looked at, there's no way you're going to become eligible. The concerns raised by Congress in 1944 are still germane. I tried to work in a pun there, German, but it's just a placeholder until someone thinks of something better. Arbitrariness of command decisions. The way to see this most clearly is between services. The use of OTH discharge between the Marines and the Air Force illustrates very much the extent to which commands can handle the same situation very differently. Someone walks in with a positive drug test. They can be referred to drug rehab, complete successfully, get an honorable discharge. They can be referred to drug rehab, pop test, pop positive again, get a general discharge for drug rehab failure. They can get an OTH on the spot. They can get a bad conduct discharge after court-martial. Same conduct, totally different outcomes, and the command decides largely how that happens. And there's wide discrepancies between service. The bottom line of this is 12% of Marines, the day they leave service, are ineligible for VA service. If they walk into a hospital, they will get turned away. The equivalent figure in the Air Force is 2%. The Air Force takes care of their people. The Marines, well, they have high standards for honorable service, and they're kind of jerks to each other. Racial bias also exists and is an artifact of the command discretion in how these happen. I would love to research this question more to understand that more, but that's data on basic discharge characterizations. Also, suicide risk, homelessness risk, incarceration risk. If you care about veteran suicide, you have to care about this group of veterans. If you care about veteran homelessness, you have to care about this group of veterans. And we're here because we care about veteran incarceration. All right, so practice pointers. If you are in a VTC, what can you do? First, remember that when you, as the VJO or whatever, look in the system, see someone is VA ineligible, remember that is almost certainly a provisional designation given by default, although no one has actually reviewed their service. There's an opportunity to get a review for that person and maybe get them eligible. Second point, the way to trigger an eligibility review is to apply for a cash benefit. Unfortunately, walking up to the hospital eligibility center does not trigger that review. Asking for homeless services does not trigger that view. As far as I know, a VJO doesn't have the ability to trigger that review. But what you can do is apply for compensation or pension, or even a home loan eligibility certificate. They're not applying for a home loan, just a certificate saying, yes, you can if you want to. That does trigger the review process. When the answer comes back favorably, take that to the hospital, and then they should honor that same eligibility decision. By far the fastest is the home loan eligibility certificate pathway. People talk about discharge upgrades. That means going back to the DOD, going back to the service, getting them to take back that OTH, acknowledge they made a mistake, give you an honorable discharge characterization. That works if you can do it. It's difficult and time consuming, but I want to acknowledge it. And finally, VA services are available anyway, and so it's important to know about this. The vet centers, which have come up, are available to people regardless of discharge characterization if they served in a combat theater, not in combat, but in a theater, or if they survived military sexual trauma. Medical care for military sexual trauma is available at VA hospitals. Don't go to the eligibility office. Find the MST coordinator. Every hospital has one, and they'll connect you with the services. And finally, currently, some housing services are available. Those are the acronyms for insiders at the VA. Regardless of it, well, not regardless, but OTH folks can get those services. So, closing slide. Chesty Puller, anecdote, did an inspection out there in front of the battalion. He said, take me to the brig. I want to see the real Marines. And he did. And he didn't go in there and free them from the brig. They screwed up. They're getting punished. He stuck with that, but they were still Marines. They still had served, and he still cared about their basic welfare. And that is the spirit which I know all of us are trying to bring to this question. Thanks very much.
Someone's going to do it. Maybe John is going to help us. All right, we need to do a PowerPoint switch here, but next up will be Professor Simone. Do you want to use that clicker? Is that how you're going to advance?
Sounds great.
Probably bring the keyboard down here if you're more comfortable with that.
That would be perfect.
Do you want to do that?
Yeah, that would be great.
Great.
I'm actually still a reservist. I'm a major in the reserves, and I defend military clients from all over the country. And because of that, you've probably heard the standard disclaimer, which is the opinions that I am presenting today are solely my own and do not necessarily represent the official positions of the United States Department of Defense, the Army, or any governmental agency. You know, the Pentagon actually made me go further based on the writing I've done. They actually all want me to tell you the military does not endorse the positions that I'm about to share with you. So buckle up, it's going to be a quick ride, okay? I think Brad's presentation was really something important for a specific reason, and I want to make sure that we all understand what it is. It's that the military has its own criminal justice system, and they have unique military offenses that we just don't have in the civilian world. So what could get you fired in a job can actually get you a federal conviction and a discharge in the military. And the sad thing is, when we're all very concerned about criminalization of mental illness in the civilian sector, the problem is that on active duty in the military, because of these unique military offenses, there is a lot of criminalization of mental illness happening. And unfortunately, the kinds of symptoms that are related to PTSD and TBI and other operational stress injuries are precisely those that will get you in trouble in these uniquely military offenses. So if you have problems concentrating at work and you find it hard to follow orders, you're disobeying orders. And if you have an angry outburst because things just build up, you might be disrespecting a commissioned officer, and all of a sudden you're facing potentially 5 years and a dishonorable discharge. So criminalization of mental illness is a problem, and attorneys who try to work with active duty service members to help them talk about a military misconduct catch-22. And what they say is, by the time you actually realize that you need help and you're earmarked as someone who needs treatment, it's too late because you're on the way out the door for misconduct. And that's something that raises major concerns because if you're 22 years old and you're barred from getting benefits and you're at risk of offending in the future, your life is going to be very difficult, and that's going to reverberate. Again, we've talked about families. It's going to reverberate to families in the community, and it's going to keep going. So there's three real areas I want to look at to address Professor Engstrom's four different categories, right? And something that might help us is when we look at the tougher eligibility decisions. And the three different puzzles that I want to present to you today involve active duty offenders in state-run veterans treatment courts. It involves sex offenders, and please don't throw anything at me when I say that. I will explain that. Sex offenders, yes. And it also involves interpersonal and domestic violence. So I want to return you to the idea of the risk matrix that they use in disaster mitigation and public planning. And they call this is one example for just an all hazards approach, whether it's natural disasters, man-made disasters, transboundary forest fires, airborne pathogens, whatever you want to talk about. There's different categories where you rate the impact, and then based on the score, that suggests the level of intervention that you're obligated to take. And if we start filling in these accepted categories for evaluating risks and a threshold to act in mitigation, we see that criminally involved veterans start to get us in the top levels of the same scale that we would use to deal with all hazards. And that's the perspective, that risk needs analysis, going where there's the most need to create the best benefits to the community and to reduce costs at the same time. It's an interesting way to look at it, but then why do we have so many problems with these three areas? So should veterans treatment courts take active duty offenders, especially considering substantial differences between military and civilian justice objectives? And we've heard about this zero tolerance that you mentioned. It's this idea that, and it's very true, as a chief of military justice at different installations, as a defense attorney arguing to military panels of commanders and military judges, it is legitimate to say you have a lot of impressionable soldiers. They're young, they're looking for leadership, and if you tolerate acts that go against your orders, then that's going to set a bad impression for everyone else. So the idea of having perceived consequences for misconduct and having good order and discipline, that's not just an empty statement. There is some value to that towards mission accomplishment. But when we start to look at the structure of the military versus the structure of a veterans treatment court, we start to see that because of that orientation, these concepts that we're using to deal with active duty problems that were created on active duty are not really being practiced where the problems originate, right? It's very hard to address active duty and raise the same kind of concerns. We actually have a system right now, and I think all of you represent that, Judge Manley especially, is you have better institutional knowledge on how to deal with criminal ramifications of combat and military trauma than the military does. And that's concerning for a lot of reasons, especially because the discharge characterizations happen before you go out into the community, and they limit the ability of the community to respond to those needs for the future. So that's a concern, and it's more like this idea of it's someone else's problem, right? We have to fight the nation's wars, go fight your battle for benefits if you can even get that review, but it's not our problem. We need to keep going. And so that idea of it's someone else's problem is really creating a lot of issues. So some basic ideas here. We don't have standing judges in the military. They only come into a court-martial when they're appointed. They go straight from verdict to sentencing in the same day. There's no pre-sentencing reports. There's no probation in the military. There aren't any probation officers. And a big problem is that in the lead up to a disposition of a case, you don't have a pretrial services division. So the responsibility to look out for the welfare of the service member and ensure that they're doing what they're doing while you're making these decisions falls on the commander and the first sergeant, who haven't been trained in elements of community corrections. They haven't been trained in principles of oversight of offenders. And what ends up happening is very often, and even to this day, you have commanders say, while you're waiting to get kicked out, don't even bother coming to formation. Just stay up in your barracks, do whatever. You're not worth coming to the formation. I see that. And so the trouble is that there's a higher chance of recidivism while we've got active duty members waiting to be discharged. Oftentimes you get more misconduct, and there's different factors here. The interesting thing is that you have the same offenders who would be eligible and able to be benefited at a veterans treatment court. Same exact kind of personal histories, same exact type of offending. It's just the way they're dealt with. So in California especially, and I think we're very fortunate to have Jude Litzenberger here, who helped to create this and knows about it, which is very exciting, and thank you again. California Penal Code section 1001.80 was established in 2015 as a military diversion program, which pretty much says if you're active duty, or if you're a veteran and you meet certain criteria, which also involves mental health concerns and the need for treatment, you're going to have a diversion from misdemeanor offenses. And there's a lot of issues surrounding that, but if we take a look at just San Diego County and its military diversion program, their experiences through the first year of that to December 31st, 2015, they've actually had 78 participants in total, and 32% of those participants have been active duty, usually Marines coming out of Pendleton or other local installations. So what we see is that even if the military is not using suspended sentences and its own veterans treatment court approach, or using local veterans treatment courts, we do have active duty service members, especially under laws like this, participating in state veterans treatment courts. And the concerns here are, do we want to do that? And it's interesting that just the types of issues that Brad has raised, the 2016 report is talking about, well, some commanders are using these programs to help save the careers of these active duty service members. But others are using it and saying, we don't care, we're going to kick them out based on the commission of defense, whether or not they get a conviction, because in the military, under these administrative rules, you can go for an OTH just on the basis of evidence that a misconduct occurred. And it's not even beyond a reasonable doubt. It's preponderance of the evidence standard. So they can pursue people whether or not there's a conviction, and they oftentimes do. And so the interesting thing here is we haven't really talked about the sequential intercept model that much, but the idea, and again, along all of the spectrums of your four categories, the idea is that at each stage of engagement with the criminal justice process, there is an opportunity to intervene and get someone on a pathway to dealing with underlying treatment needs rather than just taking a punitive approach. So normally the best place to intervene is initial engagement with police officers who are trained in crisis intervention training, which has, by the way, always had a veterans component when they're trained, which is really neat. But that's not the end of it. You've got, other types of decisions leading all the way through reentry courts after conviction, after serving time. But my idea here is that there's about 5 stages of the sequential intercept model. When we think about active duty, I think you have to add additional steps to that. And the biggest concern is diversion from a punitive or stigmatizing discharge. That's got to be a piece of that, and there needs to be coordination between active duty and veterans treatment court personnel, and exchange of information and memoranda of understanding. Now, I will tell you that when I was actually the Chief of Justice at Fort Benning, I did participate in a death penalty case at Fort Bragg, but when I was at, it's all right, I just want to clarify. I would have loved to have been at Bragg as the Chief of Justice. But when I was at Benning, one of the things we did, I think this is the first one, was a general court-martial involving an officer who would have received 2 years confinement at that general court-martial, but we made it a term of his pretrial agreement and his plea to participate in the local Muskogee County Veterans Treatment Court in Georgia. And he did, and he succeeded. And the military was very happy to not have to monitor him, babysit him, and know that a standardized approach was being used. He graduated and never had to spend a day of his confinement term. And that was at a general court-martial, and that was approved at the Army Court of ACA, the Army Court of Criminal Appeals. So that's a model we can use. We can do things like this, but there's got to be effective communication. So if anyone's interested in that, please do let me know. So yes, we should take active duty, and it's great to see the Uniform Law Commission working on that, but with the proper communication and support and between active duty component and local Veterans Treatment Court personnel. Sex offenders, how are we on time?
12 minutes.
Great, sex offenders. Something I want to talk about here, very important. I wanted to show you, I didn't just want to write it, I wanted to show you what was actually in these reports from the Bureau of Justice Statistics. 2000, they come out with a report on veterans in jails and prisons, looking at 1998 data. Did you know that in state prisons, 7% of civilians were incarcerated for sexual offenses, violent sexual offenses, including rape, but 18% of veterans were? That's a huge difference. If you look at local jails, back in that time frame, 3% civilians incarcerated, but 6%, that's double the number of incarcerated veterans. The next study, and a lot of people, including myself, wish that they would publish these more regularly because the data is so important. 2007, they looked at 2004 statistics and reported on those. What do we see? We see state prisons, 9% of civilians incarcerated for sex crimes, violent sex crimes, but 23% veterans. And then if we look at federal prisons, 0.6% of civilians, but 3.3% of veterans. Significantly greater numbers. We look at the 2015 report, which looks back on 2011 and 2012, and we find that in prisons, 23% of civilians were incarcerated for sex offenses, but 35% veterans. And then jails, you can see, they looked at both standardized and unstandardized samples of civilians, generally in the 5 to 6% range, but 11.8% for veterans. So this raises a question. I mean, sex offenders are pretty much persona non grata, right? It's like you deserve the worst you can get. Try to get housing, try to live somewhere in the community that's not near a school, but you deserve that. And when we talk about rewards for past service, well, it doesn't seem like veteran status does much for murder and sexual offenses. But the question raised here is there something about military service that may actually engender sex offending behavior in some cases? And I don't know, because people don't like to research this, but these numbers, I don't think we could ignore them. They looked at combat experience, and there's only slight increases. So if we look at prisons, 36.8% of sex offenders had combat experience versus 35% non-combat. And then in jails, combat experience 12.9% versus non-combat 11.5%. One thing I do want to tell you is the Howard League on Penal Reform started looking at offenders in England and Wales, who did participate in the global war on terror. Their statistics were strikingly similar. This is a 2011 report finding that 11% of civilians had violent sex offenses, but 25% military service. And they actually cited the then current Bureau of Justice Statistics reports to say there's something going on here. Now I know time is up. Can you do it in two? I'll do it in two. Great. The military itself in its manuals, and I'm giving you a few examples, talks about misconduct stress behavior. The idea, and they use that double-edged sword as an analogy, but the idea is that when you send service members into combat, it creates stress that can be good if you have good leadership. But on the other hand, it could be counterproductive and lead to misconduct if it's not done in the right way, and all these factors apply. But one of the things that comes out of that we see here is looting, pillage, and rape expected as a result of exposure to those combat environments in some cases. So I would suggest to you that there may in fact be a connection here, at least in some of these cases, between military service. Active duty, the Bureau of Justice Statistics looked at active duty and said violent sex offenses were the most common reasons for confinement on active duty. And again, if we look at this, just came out on May 5th, the continued high rates of sexual assault on active duty also suggests there's an issue here. Now, we talked about books. I think Aphrodite Matsakis, she's amazing. She wrote a book called Vietnam Wives, where she went to all the vet centers in the country and interviewed wives of combat veterans about their experiences and wrote a book, and that was based on that. And then she wrote this book, Back from the Front. This is really the only place where I could find a discussion of this. And I guess we avoid it because we don't want to draw the connection. We don't want to try to think, oh, there might be an excuse for sex offending because it's just such a heinous crime. We just want to stay away from that. But here's the thing. There are patterns of sexual offending that are related to combat trauma. She talks about self-medication with sex because that release has a sedative effect that oftentimes can help alleviate problems with PTSD and TBI symptoms. This idea of sexual urgency where the veteran rushes through sex, wants strictly to control every move, or in other ways enters into a combat mode in the bedroom. Hypervigilance in the bedroom. Non-consensual physical aggression as a means of trying to create more control because you are in an intimate situation where you have less control. Something worth looking into. It suggests that this might explain some of it, and if in fact there is a military nexus, to use the term, maybe we don't need the diversion approach. Maybe these crimes are very serious, but what about a reentry court approach? What about some way to use military-specific factors that may be involved in this to reduce that recidivism and actually get an amazing benefit in the community if you can prevent this type of reoffending? I want to offer that to you. I think in sitting here with Judge Manley, I've asked around. I don't think there's any other veterans treatment court in the country that would take a sex offender, but I know Judge Manley will talk about that experience. But the point is, if we really want to help protect the community against the worst crimes, let's find a way to do it. Maybe it's not going to be coddling, and maybe it's not going to be excusing sex offenses or interpersonal violence, but let's do something. No more persona non grata. Let's apply these evidence-based strategies and make an impact. Thank you.
Thank you, Professor. So batting cleanup, we have Judge Manley.
Thank you. It's a real privilege to be here, and I have no slides, so I can't show you anything. What I'd like to do is try and I'm at the ground level. I have done this for many years. I've been working with those who have served in the military, veterans, for over 25 years. And one of the things, what I'm going to try and do is talk about this because I have very strong feelings about it. And my program is very different than most other veterans treatment courts in the country. To begin with, it's very large. We probably have the largest veterans treatment court in the country. We do a great deal of diversion. California is a leader in that, wonderful statute. But it is limited to misdemeanors, and that's half the problem. There is a serious problem with felonies and offenders who are convicted of felonies, and the way the courts look at it, I think we get far too many people excluded because they're felons. And that's just nothing, it gets us nowhere. So let me just give you a few thoughts. First, I think you need to understand, we all need to understand, I certainly understand it, because I work with judges throughout the country, the fact that courts have limited resources in terms of judicial officers and staff and time to give to certain case areas. And that includes what I will call collaborative courts, which includes veterans treatment courts. And we will never, I think in my lifetime or most people's lifetime, ever be able to meet the need for veterans treatment courts. I mean, yesterday I said, I was asked some question about, well, how many do we need? Well, I said you need one in every jurisdiction, everyone in this country. Unless it's a jurisdiction that's nowhere near those who have served in the military. But we have in California, I'm not California, Arizona, we have one, I think, working in the Havasu, working with Native Americans. I mean, this is an issue which we in the courts tend to say, okay, these are very nice. They look good. They make the court look good and all of that. But we really are not serving all the people who need our help. And I think the way to come at this is, number one, I learned long ago, Brad has talked about eligibility for better. I mean, I'm the foremost authority on this one area, and that is the total frustration in trying to ever understand what in God's name they've done and why, in terms of disqualifying people. And talk about changing eligibility. Oh, my heavens. I spend more time arguing about what's going on in Oakland. We have the big office in Oakland, and we can never seem to find anything. I had a veteran on the streets. Comes back. He served in Iraq, Afghanistan. I can't remember, OEF, OIF. In any event, he and his wife didn't get along at all, and she decided he could have the kids, and she was going to go her way. He ended up on the street with 2 kids. Ineligible. Why? Because he couldn't find his paper. Somehow his paperwork was somewhere lost in St. Louis. These are daily problems that you only see if you're kind of in my position, I think, where you see everybody coming in. And so what? Well, then let me tell you this. So number one, when we formed our program, we were one of the very first in the United States. I think we were third. My friend Wendy Lindley, who's now retired, and Bob Russell back in Buffalo. So we had all had some discussion for years about this. Never done anything. Then Bob started it, and then we went and because we'd all seen veterans in our collaborative courts, drug courts, mental health courts. Why, what are we doing here? We're going to have all these newcomers coming back, you see, who are going to come into our system. We knew that in Vietnam and didn't do a darn thing. We just watched it happen, and they're all still in the streets. So when it comes to eligibility, we, in my program, we have absolutely no bar. All right? You hopefully have served in the military, but one thing that hasn't been discussed by this panel is, you become ineligible unless you've been in long enough. I mean, time is a factor. And you're eligible for medical, but you're not eligible for mental health. And, if you go down that path, you spend your life arguing and getting nowhere. So we eliminated that in the beginning and take everyone. Okay? Because here's the issue to me. It is very simple to come at this. If you have a knowledge of collaborative courts, what collaborative courts are designed to do and what they do best is work with people who have the highest need for treatment and services and are at the highest risk, not for violence, not for sex, but to reoffend by committing any type of offense. If you take, and those are the standards that we have seen through research is what judges ought to be doing. Now, if you take that group alone and you apply it to veterans, we would have 5 times as many in my court as we do now. And I have one of the largest, goes multiple days a month. And you see the need, this high risk, high need, and it's been alluded to in these presentations, particularly with the data from BJA with sex offenders. The need is there, the risk is there, and yet we are not serving them. So when I started our program and working with my team, we decided we were going to break through that. we were going to ignore that and we were going to conquer. And we didn't exactly do any of that, but we tried. And we're still trying to this day. I will tell you, the thing that shocks me across this country is you will have collaborative courts like a drug court. These are very famous. For those of you who don't know them, they are very famous. They will accept people, yet if you're a veteran in a veterans treatment court, you're not accepted. Amazing to me. You create a new model of the same thing, doing the same thing, trying to help people, and the very people that you should be supporting more than anyone else get excluded. Because the legislature and the policymakers and the judge, they all get involved in all this stuff and the DAs about. And I think there is a stigma about those who serve. There is a concept that they're more dangerous, just like mentally ill people are more dangerous. Because of all that we read in the paper, you know, he killed his wife, he did this, she did that, so on and so forth. And the way courts handle that is to stay out of the fight, you know, avoid it. I don't think it's all wrong. So to make a long story short, we use risk and need. It is incredibly important to do that. We also do not allow treatment to get in our way or lack thereof. So if the VA will not provide treatment to the offender, we use the county. Why? Because every veteran is a resident, right? Why shouldn't you be entitled to county treatment? Why shouldn't you be entitled to state treatment? So the way we run our program is for those that would be ineligible because of the acronym, of course, escapes me, but the other than honorable. You know, this huge group of people that are always, you know, well, I thought you could appeal these things, and I found out you get nowhere. You wait, I don't know what happens, but I don't want to because it's boring. I have to deal with today. I've got a guy in front of me. What am I going to do? So what we do is if we can go with the Veterans Administration, we have a whole team from there, get them in there. If they can't, we put them in county treatment, okay? So now what about offense? Now this is another way to kick people out and not give them services who are high risk and high need. Oh, good heavens, they committed this serious offense. Well, I don't believe in that. We encourage serious offenses and we get them. Now, how does that happen? See, it doesn't happen by holding a bunch of meetings with a bunch of stakeholders. What happens is, who can go into a veterans treatment court? Do you know who controls that really in a court? The judges. The judges. And if I can convince my colleagues, you know, all judges, all independent, can do any darn thing they want. You know, we have, just to show you what I'm talking about, we have this diversion statute for misdemeanors. It's extremely broad. Wonderful statute. God bless the legislature for doing the right thing for once. And I'll tell you, the problem with it is discretion lies in the judge. They left discretion with the judge. So if it's a DV case, domestic violence, and the judge says, oh, this is serious, no, we're not going to allow that. They don't get diverted. So what you have to do is spend a lot of time, and there has to be a lot of effort made in educating judges as to why treatment works and why it protects public safety. Because in my program, we take people who have been convicted or are pending felony DV cases, okay? Now that is a serious offense in my court and in my county. In this county, we care a lot about DV. We're under heavy, heavy pressure from the victims' rights groups. We have a very long history of struggling with this issue in the courts. We used to ignore it, just like we ignored veterans. So what we do is we get the judges together and we point out what is, I don't know if any of you have ever seen or know about a DV class. It's mandatory in California if you're convicted. You have to take a 52-week program. This program doesn't address anyone's treatment needs. So what happens? People that complete that program, complete probation, go out and commit the very same offense again. Because you're not getting at the core issues. And the core issues you only get to if you get in a veterans treatment court for a veteran or someone who served in the military. Now, do you think judges are too stupid to see that? No, they aren't. All of our judges, I mean, we have a fear factor because we stand for office and we can easily get thrown out of office, particularly if we make a mistake in sentencing or in releasing somebody early or whatever, and there are scary cases. But you see, if you argue to judges that what you really need to be doing is looking at public safety, you do not protect the victim by putting people in meaningless classes where they're not going to get better. If they have underlying mental health issues, if you don't address them and their drug issues and whatever else is there, you're not going to get anywhere. Well, the judges on my court accept that. And therefore, I have far more referrals than I know what to do with. You see, once you open the gates, there's no way to stop it. So that's how I got to working with sex offenders. Because you see, and Professor Simons, he's got it right. The woman who did that article, the mother who went around to all the programs or wherever, all the states. Anyway, bottom line is this. If you look at PTSD and know anything about it at all, and I don't very little, I'm a judge. Judges are pretty dumb on that, and we shouldn't know very much about treatment because then we'll screw up things. But I have seen, that with sex offenders, I know one thing, and this is what every judge in California knows. We not only screw sex offenders by punishing them more than anyone else, because then the law drives us there and policy drives us there and common sense drives us there. I'm not saying, this is not the right thing to do, but you can overpunish, and we do overpunish sexual offenders. The horrible thing is we never let them escape the sins of their past. They are required to register forever. If they're transient, as so many of mine are, they must register every 30 days. So what do you do about that? That's a public safety issue. There's nowhere they can live. Now, if they come into a veterans treatment court, what you're talking about is taking someone who served in the military, got all screwed up, became a sex offender, got convicted, or has been arrested, and you're saying we're not going to give them the treatment they could get. Let's say they're eligible, as they often are, for VA treatment. Why aren't we putting them in treatment? Because we know one thing about sex offenders. The only thing that will ever work with them is treatment. It's the only thing. Behavior modification, that's what it's all about. And they have to register every 30 days if they're transient. If they don't register, which means go to the cop's office where they're delighted to arrest you for something else, you then face a minimum of 6 months in jail, and you end up going to prison again. This is all ridiculous. Wearing monitors, it's wonderful for public safety if anybody was watching it and doing something about it. But instead, they reside along public trails in my county. They reside out there along the Coyote River or creek or whatever one we call it from one day to the next. And we have, it's a serious problem that needs to be addressed. So I take them and we work with them and we actually have success. Regardless, and believe it or not, I had a graduate, I think he was 93, Korean War veteran, sex offender, huh? Here's a guy who went to Korea, fought for his country. You could have at least done something along those whatever number of years since he got out home from Korea. And we end up doing something for him when he's 93. Sad state of affairs, but that's what you have to do. And the final thing, I would really say is that I really think that we need to be more aggressive in pushing the courts to understand that there is such a close, to me, nexus between some of these major illnesses, PTSD, and crimes. Reckless behavior is drunk driving with serious bodily injury. Hypervigilance is slugging people in the face behind you in a bar, coming out of a bar, walking down the street. These are all directly related to crimes that are committed every day. And if we don't get smart about this, we're going to screw it all up and end up like we did after Vietnam, where we completely ignored veterans and did nothing for them. Absolutely nothing. We could care less because it was an unpopular conflict. Nobody wanted to deal with it. And the more we try to isolate veterans treatment courts to only dealing with combat veterans or others, the worse we get. I think my time's up. Do I have it? Great, because I like questions better than talking. Thank you.
Okay, so we've had 3 spirited presentations. Thank you to all of you. We have about 20 minutes for questions. This is the last panel, so this is your last opportunity to get in front of the microphone. So hopefully we'll have plenty of takers.
Hello. So again, Rabia Bell at Stanford Law School. This is sort of a comment/question at 20,000 feet, but it seems like one of the big things is that there's a real entanglement of as I've been listening to the panels with the politics of respectability and the era of mass incarceration, where if you commit a crime, then we will throw you in jail, we will throw resources in your direction because we will always pay for prisons, but we have a moral threshold when it comes to actually receiving social welfare provisions. And at this point, it seems like we're only willing to do so within the boundaries of the carceral state, instead of giving benefits to people, social welfare benefits to people that don't commit crimes. And what I worry about is what it seems like what could happen with respect to veterans is that veterans score really high on the respectability ledger and can receive, some veterans, and can receive benefits that other people cannot, but we don't want to necessarily continue this politics of respectability because it's going to leave a lot of people out. People like sex offenders, people who are not veterans that have the same type of conditions such as PTSD that are going to remain on the streets even if we go and we take all the veterans out. So I just sort of wonder in terms of how we can really sort of hit the nail on the head in terms of eliminating this moral requirement to receive the care and treatment needed just to be a citizen in American society instead of just locking people up.
Does anyone want to respond?
Well, you're right. I think the way we change it is to me very simple. The punishment system, and I have been a part of that for years, has completely failed. I mean, it's a complete failure. I mean, we have realigned, we keep realigning and changing things and shoving people from the prisons to the jail. And I will tell you, I know the Secretary of Corrections, I was with him, I don't know, a few weeks ago. And do you know that now we're under a cap? If we add more than the cap to our state prisons, we have to order them released, just release people. After all we've gone through, all these changes in the law, trying to solve this with legal law, stuff like that, and definitions, and put them in jail, we are within 1,500 prisoners of the cap again. We went down and now we're back up. You cannot get your way out of this mess by building. And so what we really need to do, in my view, the court should be leading the charge to providing more and more collaborative courts to deal with more and more individuals who are in the community, not veterans, but keep getting sucked up into our criminal justice system because of their poverty, their lack of benefits and services. And that's what we ought to be doing. I mean, that's my answer.
I would say that, it's such an important question you raise, and there's so many aspects of it, but I do think that we should recognize that incarceration oftentimes, and even if people cannot get diverted from incarceration can be, if it's made constructive enough, a way to finally slow down and constructively use time if you have something to use it with, right? And so I've been exploring this concept of specialized housing units in jails and prisons recently. And the idea is as many specialized approaches as we could come up with, especially in incarcerated populations, we can start to at least make it more productive and useful as we're working through these issues. So they have fatherhood dorms, faith-based dorms, veterans dorms, GED dorms, and maybe there's a way at least to try to focus on individual specific needs and allocate the most resources while they're there as we work through the broader picture.
Hey, how's it going? My name is Chris Goslin. I'm a United States Air Force veteran. I want to personally thank the two judges for what you guys do, and obviously we have two very dedicated, big-hearted, no BS guys, and I hope that you guys will work together more often if you don't already. All right, great, good. So I'd like to just give a little food for thought for you, Professor. Given your statistics, it seems like veterans in the criminal justice system and largely are outperforming their counterparts in a very negative way. I just want to give a little food for thought that I work in veteran entrepreneurship and also on the public side as well, and veterans actually outperform their counterparts in a very positive way for veteran entrepreneurship. for Fortune 500 executives and also for serving in public office. So the food for thought that I like to suggest is that veterans, when they're coming out of the military, they have a unique place and time where they can choose a path to go down. And if we get to them at the right place and time, and if there's some type of mentorship system, or there's a breaking from like bad behavior to good behavior, and we can provide opportunity to veterans, I think they'll outperform. And it's our choice as a society whether they're going to outperform in a negative way or a positive way. But my food for thought is, I promise you, they'll probably outperform.
Thank you for that.
Just want to quickly say that I recently, Judge Manley, I was really listening closely to what you were saying about what should be done, and I think you actually have it. I recently attended a session at the Judicial Council. So when you talk courts, I always thought, well, where does this go? Oh, someone said Judicial Council. So I went to San Francisco and I sat in on a meeting. And it was interesting because a lot is driven by judges. You know, they're all judges on the council, right? And I actually had a chance to see, I sat through the whole entire day. And before lunch, I saw a judge present an issue. And he was coming up with he basically painted a scenario, and he showed how a special program to divert people from being in jail had worked, and they had data, right, to show that it worked better than it was regarding bail. And they essentially showed it was better to not have someone sit in jail and to have this special program, and they showed the data how it was more successful than having someone in jail. Now, after lunch, another issue arose where this same concept could have been used. And the basic idea is what they were doing was segmenting the individuals. The public safety piece is about trying to remove people who are really dangerous to society. We have to have a way to do that. So the segmenting allows us to figure out who's actually truly dangerous and who's not. So when this other issue came up, I asked the same judge at the end of the session, I said, I think there's commonality here. He said, no, they're completely different. Then I explained it to him again, and he said, oh, yeah, maybe. So judges themselves may have a little bit of a roadblock in seeing some of these things. Judge Manley, what do you think about, because you all are elected officials and you do have a particular advantage on bringing things to the Judicial Council, who actually help supervise the courts, what do you think could be done around that as far as the community working closer with judges? Judges typically are more removed from the public. Is there a way to get closer to the community so we can have a little bit more interaction and get some more traction on this kind of stuff?
Yes, yes, but I think it is not going to be at the level of the Judicial Council. I mean, this only applies to California. Other states are different. But in California, the Judicial Council is, in fact, if you want to call them in charge of the courts, they are responsible for the third branch of government. But we have 58 superior courts, and each and every one of them is separate, individual, independent, and don't necessarily get along with each other or agree with each other about anything. So the way to do that, and what I try and urge people to do, every superior court, and I think this applies to any state, there's going to be a presiding judge. That judge is the most susceptible to being influenced by the public. Generally, presiding judges do not like to have criticism during their term, at least, of the court or themselves. And so I urge always people to go to, when they say, well, I want to start a veterans treatment court in this small county in California or wherever, I would say, go to the presiding judge, because everything in California is local. Sure, we have a huge prison system, but they all come home and they're all local. So if you're going to really affect change, and that's why what goes on in San Francisco and what goes on in Orange County and what goes on in Santa Clara will be very different, will seem weird. But that's because everything's local. And how it comes to be more similar is when more and more courageous judges, like my dear colleagues here, get out and do things, and then it is observed by other courts. They then tend to move in our direction. And that's the way things happen in California. The Judicial Council sets major policy. They may take very positions with the legislature and with the governor. They're responsible for fighting for the court's budget because we are dramatically underfunded. And this is one of the reasons we don't have enough veterans treatment courts. We don't have enough judges. We don't have enough staff to make them work. But that's the Judicial Council's job. Basically, the veterans stuff, the community stuff is all at the local level. So that's where you want to put your effort. Is what I would urge.
Oh,
Over to this
thank
side
you.
now. Thank you.
I do live in San Francisco County, and one of the things that's kind of a hot topic right now is something that we have for people from other countries. We have something called sanctuary cities, where they have federal protections. We try not to step over their boundaries of getting into any kind of deportations. So, but here I say, okay, if we're going to use one class here, why not veterans on these veterans courts too protect us? So this is sometimes I want to present this to policymakers, professors, law professors and scholars and the community here, that we can use that argument as well, saying, hey, we're creating sanctuary cities all over the country. That, you know, they're not going to comply with federal courts of, reporting them to the police because they don't want to disrupt their lives. So I'm thinking, okay, can we somehow piggyback off that as scholars and professors and community leaders here, veterans advocates, say, let's look at, you guys are the professors at Stanford, and I'll help you guys out too. So I'm just saying, can we begin to scratch that? And Brad, you're with our plowshares too. So, and here's Judge Ross, San Francisco County. So I think I'm among some really good, smart people that we can say, hey, if the courts are going to be overlooking this, then we need to be using the same argument against them. And so that's where we get them back at. So, and I'm also trying to get into law school, so just remember me, okay, guys? Selling myself out. So, okay. Thank you, Brad, about the statistics about racial biases of our Marines. I am American Indian, and I was in the brig too, but I got out. Thank you, Professor Evan, for the work that you do. You stick up, stand up, and here I am honorably discharged, 20 years now getting my benefits. So thank you very much. So Judge Manley, I've also fought the city and county of San Francisco in administrative law court. I won that veterans can now get county mental health service with the county. And the VA, the county was fighting me, so that case was named after me. So I have that, I've stirred the pot. I'm just kind of here. I'm here to share, say that there's some of us I don't have a college degree yet, but you guys will help me get in, right? Right, all right, so I'm sorry.
Thank you so
all right.
much.
Thank you.
Just head over here. Great, sir.
As the chief legal officer of the Special Court Martial Convening Authority at Fort Ord, I was responsible for producing transcripts for the Court of Military Appeals. And I got a call one day saying I was falling behind in my transcript production, and I got an introduction into getting what you paid for. And what we are paying for right now is we're paying for recidivism. We're not getting results. You get what you pay for, and that's why you need to follow the money. And that's where I got introduced into how to get around the requisition system by constructing a very useful RFP that was limited to one sole source provider. So I believe that the greatest service the judiciary can do to all of us is to take a look at what you're getting, and I think what you're going to find out is that you're getting a recovery racket that keeps putting the same people back in front of you We've got to quit paying for recidivism and start paying for lasting results. And I urge the judiciary at all levels to take a look at whether or not their decisions are supporting a recovery racket or whether they're really getting the results they want. Thank you.
Okay. So we have about 3 minutes left, so it might just be perfect to take your question then and maybe any responses.
Good afternoon. My name is Socorro Gonzalez. I'm an attorney with the Santa Clara County Public Defender's Office, and I work in Judge Manley's department, Veterans Court. And I have a question for Professor Simone. You mentioned some statistics regarding sex offenses and veterans. And as a criminal defense attorney, I have to present to the court the nexus between the crime, the sex crime, and any type of military sexual trauma, mental health issue, or substance abuse issue that they acquired while they were in the military. Now, just with my own personal knowledge of certain cases, it's very difficult to find documented or information documented in VA records, for example, regarding military sexual trauma. In fact, I had a case where there were like 2,000 pages of mental health records, and it was just one entry. But I was able to find it, and I was able to establish that nexus. Are there any other, are you familiar with any type of other documents, for example, that we can look to, or do people actually report the military sexual trauma that they may have experienced? Is it something that's followed up on, or is it something that's kept, hushed?
I just want to clarify, are you asking about whether your own defendant may have experienced military sexual trauma?
Diversion.
Yeah, for diversion. Again, the biggest concern is getting people to report in the first place. And you oftentimes, I mean, the studies being done on military sexual trauma benefits and the fight, that they call it the second battle to get benefits for that. Oftentimes, one of the biggest problems is the lack of documentation near and close in time. I think one of the important things you can do to support your clients is to try to get them attention from the VA and have explanations for why the lack of documentation is a common thing. That oftentimes works in the women's trauma units when there's documentation to, treatment providers at the VA can supplement their analyses and explain the context of what's happening. So you can do the same thing, and I think it would be important because in most cases there's such stigmas against reporting, especially back before there was interest in helping survivors and really devoting resources and before restricted reporting. The chances are there's not going to be much at all. But that can be explained, and that is not out of the norm. So I would say address that through professional channels as well. Yeah.
Can I supplement that? Can I just add something that in the context of VA disability claims, you also have to prove that the assault happened. And the VA has formally and explicitly established very low evidentiary bars, and they do not require an explicit report of the assault. They will also accept any circumstantial evidence of behavior change that's consistent with an assault. And so maybe this is something to be included in the model court statute, where when a nexus is required to formally write in a low evidentiary standard, and maybe with reference to the practice in the VA as another forum where that's been done.
Yeah, in a number of BVA decisions where they've actually granted benefits, looking at the sufficiency of the evidence, they look at things, and there's actually a list of factors that help corroborate, right? But you could have requests to be moved from a location where the perpetrator was. I've even seen cases where they say if someone throws themselves into work and just works nonstop and becomes like an amazing worker just because they can't bear to do anything else, that can be proof. Or trying to get married just to get away from a perpetrator. Accounts of people who were significant others at the time and witnessed personality changes, behavioral changes. I remember one opinion that stands out to mind where it was a couple and they were engaging in just roughhousing, and all of a sudden that triggered an experience, and that partner wrote about that, and that was looked at as evidence close in time to support that the assault had happened. So that's a great point. Yeah.
So it's been an honor for me to be part of this conference, but it's been a particular honor to sit at the same table with the three individuals to my left. So let's thank them all for being here.